Hello everyone, this is Priya and the topic that we are going to be discussing today is the Indian Penal Code 1860. The Indian Penal Code, which consists of 511 sections, which is divided into 23 chapters. So it was enacted in 1860 by the recommendation of First Law Commission, that is British India Commission, जिसके head थे Thomas Babington Macaulay. This question has been asked that who has drafted the Indian Penal Code 1860. So it was Thomas Babington Macaulay who drafted the IPC in 1860. So actually it was Britishers who had made this law for India. Although IPC was enacted in 1860, but it came into force on 1st January 1862. The Indian Penal Code deals with substantive law of crime. Now what is substantive law of crime? So among the branches of the public law, criminal law is broadly divided into two categories, namely substantive law of crime and procedural law of crime. The substantive law defines various offences and prescribes punishment for the respective offences. Substantive law is embodied in the Indian Penal Code 1860. IPC एक substantive law है क्योंकि it defines various offences and prescribes punishments thereof. For example, what is rape, what is assault, what is murder, robbery, it's all defined in IPC. And if the person is convicted, what will be the maximum or minimum punishment, what will be the fine, these are all defined in IPC. For example, a section 300 of IPC defines that what amounts to murder, and section 302 of this code prescribes the punishment of the murder. On the other hand, procedural law of crime, as the name says, provides mechanism or procedure for the enforcement of the criminal law. बेसिकली प्रोसीजरल लॉ में ऑफेंस करने पर पनिशमेंट या रेमेडी कैसे मिलेगी उसका स्टेप बाय स्टेप प्रोसीजर, उसका मैकेनिज्म डिफाइन होता है. फॉर इंस्टेंस, इफ एनी पर्सन हैज committed an offense, then how that person will be arrested, how the investigation will happen, how that person will be produced to the court, how the warrant will be issued, process of trial, ऑर्डर कैसे देंगे, फाइनल डिक्री कैसे दी जाएगी, ये सारा का सारा प्रोसीजर डिफाइन होता है इन प्रोसीजरल लॉ, लाइक CRPC. सो CRPC इज अ प्रोसीजरल लॉ. On the other hand, IPC is a substantive law which defines crimes and prescribes punishment. Okay. So in simple words, IPC में ये डिफाइन होता है कि किसी क्राइम की पनिशमेंट क्या होगी, वो क्राइम डिफाइन होगा और उसकी पनिशमेंट क्या होगी. पर जो प्रोसीजरल लॉ है उसमें उस पनिशमेंट को हम देंगे कैसे, कैसे वो पनिशमेंट दी जाएगी, ये डिफाइन होता है. Is the main criminal code of India and it defines and punishes various offences which can range from fine to imprisonment to the death penalty in certain cases. As far as the applicability of the Indian Penal Code is concerned, it extends to whole of the India, including the Union territories of Jammu and Kashmir post the passing of the Jammu and Kashmir Reorganization Act 2019. Before 5th August 2019, IPC would not be applied on the state of Jammu and Kashmir as it was given a special status under Article 370 of the Indian Constitution. So back then IPC was applicable elsewhere in India but not in Jammu and Kashmir. They had their own criminal code, that is Ranveer Penal Code, named after Maharaja Ranveer Singh. The RPC has been dissolved now and Indian Penal Code 1860 has been extended to the state of Jammu and Kashmir as well. So in conclusion, Indian Penal Code was made in order to deter the crime against the society, drafted by Thomas Babington Macaulay on 1st January 1862. It is a substantive law which describes different offences and prescribes the punishments. It is a territorial law which extends to the whole of the India, including Jammu and Kashmir. So here I am concluding this video. In the next lecture, we will be covering the jurisdiction of the IPC. Thank you for watching.